SJC-13841, Crown Communities LLC versus Pocasset Park Association, Inc. et al.
Okay, Attorney Leonetti.
Ready, Your Honor? Good morning. May it please the court. Kenneth Leonetti of Foley Hoag. With me are my colleagues Mark Finsterwald and Jasmine Brown. The court should reverse the trial court's judgment in favor of the Pocasset Park Association because the association failed to establish that it complied with all the requirements of the Manufactured Housing Act. Specifically, the association failed to obtain a mortgage commitment within the statutory required 90 days, failed to submit an offer that was substantially equivalent to the Crown purchase and sale agreement, failed to provide reasonable evidence that a majority of the resident owners of the park opted to exercise the statutory right of first refusal. Your Honor, I'd like to start with the purpose of the statute. I think an overarching structure is important since all the parties have argued it, as well as the amicus. We agree with the Attorney General and with the association that the act is intended to protect residents of a manufactured housing community from unfair practices, arbitrary distributions of operating costs, evictions, park closures, monopolies on services, and also to provide an affordable option for elderly and low to moderate income residents of the Commonwealth, as this court recognized in Greenfield. There's no risk of that here, to be clear. Crown, my client, is committed to, if it gets ownership of the park, to maintaining it, to investing in it. They are a good steward of these properties, and in fact, they are in this courtroom today as well to see this argument, to hear this argument. But talking about the policy is not the same as saying, as both the Attorney General and the association seem to be, that the language of the act should be bent or ignored to ensure that residents can exercise a right of first refusal no matter what. So by creating this statutory right of first refusal, the legislature has drawn a balance between the residents, the community owner, and the third party. The right of first refusal has limits to get a financing commitment, to get signatures, and they have to make a substantial equivalent offer. And there's a good reason for those restrictions, because the property owner is statutorily compelled to give up valuable rights and holding the third party sale in abeyance, which is in no one's interest, because if the residents cannot get the financing commitment and the third party is gone, there may be no one willing to buy the community.
Can I ask a question? I understand that there was an issue with regard to the lease pendants that was filed.
Yes.
Can you just talk about why that should not have been an impediment?
Yes, Your Honor, and that gets to the 90 days argument. So there's two problems with the lease pendants argument, and why that somehow either exempts the association from having to comply or stops Crown from arguing it in the alternative. First, there was no evidence, no witness testimony that the lease pendants thwarted getting the mortgage. Second, the actual evidence undermines this argument because the association did get a mortgage commitment eventually, albeit 180 days, so double the statutory period. But they did get a commitment eventually during the time that the lease pendants was in place, and actually relatively early in the time that the lease pendants was in place. Now, in its papers before this court, the association has put a different spin, I think, on the lease pendants argument. They're basically saying that the mere fact that Crown filed a lease pendants stops us from complaining that the statutory deadlines haven't been met. And the argument is based upon the assertion that the lease pendants was filed for the purposes of thwarting the association's attempt to obtain a financing commitment. I will say there's nowhere in the record to establish that. And again, there's no causality here. And what the association seems to be relying on is the appeals court's articulation of what appeared to be a per se rule that excuses their meeting the statutory deadline when someone files a lease pendants. And what that appeals court decision down below, in this case, on the first appeal, cites to another appeals court decision, August Corp versus MCAD. But if you look at the actual language of August, what it says is, quote, a party that frustrates, innocently or otherwise, another party's ability to comply with an obligation cannot complain about the failure to meet that obligation. In other words, there has to be a causal link. Here, there was no frustration of the association's ability to get a financing commitment.
Could I ask you one question?
Yes, Justice George.
So one of the things that seems to kind of bubble up in what you're saying, there's a rigidness to what you're saying that doesn't seem to comport with what you started with, and that's the statutory purpose. And so the statutory purpose seems to suggest that this is a remedial statute. And so when you start talking about things like substantial equivalence, why does that mean identical in this context? I mean, mortgage contingencies are commonplace, right? So it doesn't necessarily defeat equivalence, does it?
In this case, I think it does in this case, and for two reasons, Justice George. First of all, if you look at the statute and the way the statute is structured, you know, the clause that has the 1, 2, 3, and 4 of the requirements, you know, which contains the substantial equivalence. Then there's another part of it that's in the very next sentence in the statute. What it says is that the residence or an association has 90 days to get a mortgage financing commitment. So the legislature was certainly...
Doesn't that support the idea that they're contemplating a group of people of moderate means are going to need financing?
So yes, Justice Kefker, I hear that concern, and that certainly is articulated in a number of the papers, including the amici. And the reason why I don't think that's an issue here is because there's two different things that are going on here. One is you have to submit a substantially equivalent offer, which we contend is basically the same. You know, if you think about a real estate contract, there's 3 or 4 things that matter in a real estate contract.
Well, what about the word substantially? It doesn't say equivalent, it says substantially.
It says substantially. And so, but a mortgage commitment is certainly something that's substantial. It's one of the 3 or 4 things that matter, you know, in any real estate purchase and sale.
I agree in a purely private sector transaction that offering money versus offering one with a mortgage commitment would be different. But we're dealing with a statute involving people, again, of moderate means, and the legislature seems to have a 45-day idea and a 90-day idea, and the 90-day idea incorporates a mortgage commitment. And these people can't do this without mortgage commitment.
So, Justice Kafka, there's a
They're
difference.
not carrying around $3 million.
Agree.
Like your client is.
I completely agree. I get that and agree with it. The difference here is there's a difference between having a statutory period to line up your financing and having a mortgage contingency in the offer. This is actually a distinction with a difference. And the reason why this is a distinction, an important distinction, is what happens is the association or any group of tenants has to submit an offer that's substantially the same, which in this case is all cash. But they get 90 days. The legislature has given them 90 days to find that cash, to line up the financing. And this gets to the balance that has to happen, because the reason there are limits in this. I mean, the legislature could have said 180 days, they could have said a year. What they've decided is there's a balancing act here, because the only way these properties ever get sold is if a third party comes in and wants to buy it. And they set the floor, and they've done all of the work. And so a substantially equivalent offer has to meet that, and the legislature's had that balance. Now,
But that balance, though, when you say the statute imposes deadlines, but doesn't the balance necessitate that it be read within its remedial purpose? Because, you know, these minor technical defects, I wonder if that should void the resident's right absent some really material prejudice.
well, the material prejudice is that, well, there's two. There's one specific to the case and there's one general. The material prejudice specific to the case is that the third party is not going to stick around necessarily a long period of time. And if for some reason, if God forbid the residents can't raise the money, then the trust continues to own the property. And I think we all agree, both sides, that this property needs an investment, needs money to come in, which is something that Crown is committed to do. But back to your question, Justice Kafka, which is, what's the difference? You know, I think with the difference is that if they submit a purchase and sale agreement that's substantially the same and doesn't contain a mortgage commitment, and then they don't get the financing, then they're in breach of the agreement, right? And so that's what happens.
I feel like you're you're setting up an impossibility. People who live in a mobile home community are not going to be able to do this without a mortgage commitment. They just don't have that. These are people who are, not going to be able to raise through their savings, millions of dollars. So it just doesn't seem realistic unless we read it in context.
Well, no, but I think the realism is they can submit an offer that's substantially the same, which is an all-cash offer,
How can they do that without the cash?
because the legislature has given them 90 days then.
90? Just tell me give me how that could possibly be done without a mortgage commitment.
So the residents of the association submits an offer that's substantially the same on whatever day, let's say, February 2. Or,
I got 80 people of moderate means. How are they going to do that? They don't have, $1 million 401k plans, right? I mean, they've got to put their units and all their interest in play, and the only way they can do that is through a mortgage commitment.
right, and the legislature has said, so all they need to do is submit an offer that's substantially the same, which is this is an all-cash offer. And if they get to the end of, if the 90 days run and they get the mortgage, because the legislature has then given them 90, they basically get a 90-day stay. They submit the offer.
So can we move on to your next argument? Not that this is not an equivalent argument, but that they failed to close in the 90 or get the financing in the 90 days?
Yes, so they did, well, so they failed to get the financing in the 90 days.
Just you're more familiar with the facts. So they submitted an offer when?
They submitted an offer at the end of January
What date though?
2020. I don't know the exact date.
Okay, but then,
January 30th.
so you're saying that, and then the financing came in when?
In July.
Okay.
Yeah, so it was 6 months. It was 6 months. This was not like a footfall, and by the way, to your question.
And when did you file suit?
When did we file suit? We filed suit in early April. So it was still within the 90-day period.
So before the 90 days, you filed suit?
Correct. Correct. And got a lease pendants. But there's no evidence that the lease pendants would have affected the ability to obtain financing because.
You don't think that the trial judge could make a reasonable inference that a property that is being subject to litigation and that has a lis pendens would be that a lender would be hesitant or at least delay offering financing to a property that changes into that status while it's looking into the giving financing?
In the abstract, yes.
Okay, so why isn't that enough?
Because here it didn't interfere. Because here the evidence is because this group, the group of.
You're in a tough position when you're arguing facts because this is post-trial. So the standard of review is difficult for you. So you need to show that the judge's finding that it did interfere or did delay is clearly erroneous.
So I don't think that, with all due respect to the trial court, I don't think they actually made any findings of fact in the remand order. There's one sentence that basically cites the appeals court decision in the first appeal. And that one sentence is basically saying just as a matter of, it's almost like as a matter of law, if there's a lease pendants, it's going to prevent mortgage financing.
What's the purpose of a lease pendants?
The purpose of the lease pendants is to prevent conveyance of the property. Because what would have happened here is if we didn't file the lease pendants, but we sued anyway, the association would have closed. They would be free to close on the financing. And at that point, the horse is out of the barn. There's no ability. So you have to file it to prevent the conveyance of the property. But again,
so
this group,
your argument is, although you did that, the owners, the residents of the Residents Association, nonetheless, were required to obtain their financing and close or just obtain their financing despite this changed circumstance. That's the argument?
correct.
Okay, and that would be, I guess, a legal argument?
Yes,
Non-dependent on the facts.
not dependent on the facts.
So you would say they would be required. Now, can you tie that position to a interpretation of the statutory requirements that would be consistent with the salutary purposes of the statute?
Yes, the way I would tie it to the salutary purposes of the statute is that there needs to be some time limit that needs to be enforced, because if it doesn't, third-party purchasers are not going to come around. They're not going to be interested in buying these properties. So what's going to happen is the owner is going to continue to hold them forever.
Why
and as
is
in this
the
case-
first 90 days to obtain financing important and not the second 90 days to close?
Well, I think Justice Wendland, they're both important.
So if you file suit preventing the closure, which was the whole purpose of your suit, I guess I don't understand your argument as to the 90 days financing that doesn't also apply to the additional 90 days to close.
Well, because closing is a legal impossibility while there's a lease pendants. There's a difference between a practical impossibility and a legal impossibility. And
What is that difference? I mean, if the point of lis pendants, which is the sort of in its name, to let the world know this property is subject to litigation, which has the effect, generally, as you've said to Justice Wolahojian, of warning mortgagees from lending money on this property because it may just go away. I guess I'm just kind of confused as to your argument that the closure could have been delayed as a legal impossibility despite the strict deadlines in the statute, but the financing had to be obtained consistent with the strict deadlines in the statute,
Well-
given where you started, which is the salutary purposes of the statute.
Right. Well, the closing just can't happen. Whereas you still, in this case, the facts clearly show that they were able to get their financing because these organizations, there are organizations that help residents like this that come together. It's a company called Rock USA and also CDI.
Is there a reasonable inference that the delay in getting the financing was caused and occasioned by the purpose of the lawsuit, which was to prevent closure?
They could have put on evidence at trial, Justice Wetland, which they didn't. There was no evidence introduced, and so you're making an inference that
Which
is not
apparently the
supported by
trial judge did. I know you're saying it's just based on what the appeals court said, but it's a fair inference.
He made it on the remand case, so it was very clear.
I'm sorry.
The trial judge made that finding on the remand decision.
Yes.
So it was without taking any new evidence. So it was very clearly based solely on the appeals court decision.
So your position is that because of the procedural posture of the case, that inference was clearly erroneous.
Correct.
What's your best legal proposition for that?
Well, it's clearly erroneous because there's no evidence. Something can be clearly erroneous if there's absolutely no evidence in support of it. And in fact, there's evidence, the only undisputed evidence contradicts it.
I'm sorry, what was that? The actual financing in April?
Yeah, in July.
Okay, sorry, yeah.
Before we lose you, could you address the timing of the 51%? Because the statute just says at least 51% shall have the right to purchase, provided submits the owner reasonable evidence, the residents, at least 51% have approved the purchase. Why do we not just look at that once? Why do we keep going back? Because particularly, just let me load the question, given the ability of the other purchaser to sort of buy off people in the process.
So, so the reason I know this gets to the withdrawal question, Justice Kafker. So the way I think it needs to be read is initially they need to submit the approvals of more than 51%. But I think if people withdraw prior to certainly the time that the financing is obtained, that should be legitimate.
Where's that in the statute?
Well, if you read the statute, it doesn't say it, but if what the statute says is that they have to submit.
I'm just wondering if this is a moving target because you come in with financial incentives and people change their mind. Is this an ongoing poll of the community?
So it comes to an issue of, I think implicit in the statute is this concept of democratic norms, which requires informed consent. And so because no one's even seen the terms of these financings, and the amicus brief of the Manufactured Housing Institute lays out very clearly, Your Honors, how this is not a great financial situation. Now, the residents could decide, in fairness, that they don't care. The value of owning it is better than the fact that they're being locked into most of the payments are interest. There's a balloon that's due in year 10 that's going to be about 80% of the principal. They can't build equity in the property the way a traditional homeowner would. So there's all of these things. And that only becomes apparent when the financing commitment gets submitted. And so if you think about the concept of informed consent, people need to know what it is that they're signing up for, because this is, as everyone recognizes, these are low and moderate income individuals. And so to layer a substantial financial commitment on them is something that maybe they want to do and maybe they don't, but there needs to be some concept of informed consent.
Kind of ironic that you're holding, you're looking at the strict, words of the statute in some places and wanting us to read things into other places.
Well, it says, Chief Justice, but it says submits to the owner reasonable evidence that residents of at least 51% have approved the purchase of the community by such group or association. Right. It's the have approved. And so anytime prior to get the financing, you could certainly pull out and not go forward. And that's where the concept of having, I think the court can read having approved, along with the salutary principles of the statute to say that there needs to be majority consent before someone signs on the dotted line and gets that big financial constraint.
Okay. Thank you.
Thank you. Thank you, Your Honor.
Okay, Attorney Ellsworth.
Thank you, Your Honor. Good morning. May it please the court. Tom Ellsworth. I'm joined by my colleague, Claire Todd. We represent the Pocasset Park Association, Inc. I guess I'd like to start briefly with just touching upon the purpose of this statute, which the court has already addressed, which is solely to protect the interests of the residents. And to protect them from what? This court has said in the Greenfield decision and referred to it in the Blake decision, to protect the residents from landlords.
Well, but this is a little more complicated, right? Because
Yes.
what it's trying to prevent is people who have their mobile home, that you sell the property and they're going to be homeless. And here you're actually dealing with a little more complicated situation, which is someone else is coming in and is going to preserve it as a mobile home. I'm not sure that's exactly what the legislature was most frightened of. What the legislature is frightened of is turning these places into something else and leaving these people without houses. And I'm a little worried there's a danger of a Pyrrhic victory here, which is you're going to end up with not having a mobile home place because it's going to go bust. But go ahead.
That is true, but only in part. This court was very clear in both Blake and Greenfield that the protection is to protect against a change of use, but also to prevent abuses by landlords. So change of use was one of the concerns.
I get that, but so let's walk through this a little bit because, the issues about whether these people can actually purchase the community and what are the requirements to make sure that it's a real alternative to purchasing. I think that's the rub here a little bit, which is, okay, you're getting 51 people to sign a petition is a lot different than getting 51 people to get a mortgage and, put up their lives, savings, et cetera. Because again, just what you say, they don't really get they don't have the kind of equity that a normal person gets when they get a mortgage, right? So I'm just trying to make sure I understand this case.
Well, Justice Kafker, those are important questions. There was trial testimony. It's in the record about how this all works. And it's all through a very well-organized group of nonprofit organizations that come in and assist the association members to form and to go through the legislative process that they need to go through to exercise the right of first refusal and to secure financing. There is an entire group, a finance group, nonprofits.
So what was the evidence on the financing? Because it sounds like financing was not obtained in the 90 days. Why is that excusable?
It's excusable because of the Liz pendants. And I do
What was the
think
evidence that the Liz pendants had any effect on the ability of the association to get financing?
there was none other than the fact that that there was a delay in getting it. But there was no direct
Were
evidence.
there attempts by the association to get financing within the 90 days that were turned down because of the Liz pendants?
We believe there was.
Well, what was the evidence of it other than your belief?
There was no evidence presented at trial. Think of it this way.
So how do we affirm that? I mean, your opposing counsel is saying that's clearly erroneous because there's no evidence, and you're saying, yeah, you're right, there is no evidence.
So
where is that?
It's a reasonable inference. It's
Is
an
it-
absolute reasonable
Is it a
inference.
reasonable inference when the association comes forward with no evidence that it even tried to get financing and was rejected because of the Liz pendants?
The issue wasn't contested. It wasn't contested at trial. And the reason it wasn't contested.
Where is the argument at trial or to the judge post-trial after remand that the Liz pendants was the reason why the 90 days was not complied with?
There was an argument in the post-trial briefing that it was the Liz pendants. Prior to that time, and I think this is why there was no contest about the timing of the financing, was because of the COVID orders that this court put in place that stayed all statutory deadlines. We tried the case, and it was right after the case was tried that the Gray Court decision came out and clarified that those extensions only applied to court processes. But that's beside the point. Think of it this way. How would we prove that at trial? How would we prove it?
Well, you
Reasonable
could
effort.
show that we applied
Yeah.
for a mortgage and it was denied, and bring in the mortgagee and put up the witness and say, yeah, the Liz pendants warded us off.
Yeah.
How many
those are-
mortgages
aren't those,
do we have
but those
to
are
run?
standard terms,
Sure.
right?
Yes.
That there's a description or definition of what reasonable efforts are. And you could certainly, to Justice Wendland's point, show that we applied. We
We could have. And there may have been evidence from Mr. Danforth that we did apply. I frankly don't recall. But the point is this.
Are you
and that is-
saying we should read Danforth's to see if there's something in there?
I think so, yes, Your Honor. But also, it's got to be that it is a reasonable inference. The appeals court said below that a party who who records a Liz pendants, the purpose of which is to interfere with financing and to stop the sale, cannot be heard to complain that the statutory deadlines aren't met.
Was there
The
evidence?
problem with that position a bit is that the trial judge did actually find, citing evidence, that there was no bad faith on the part of Crown Communities. And so if there was no bad faith, they filed their lawsuit in good faith. And Liz pendants is just something that happens when you file a lawsuit related to real estate.
That's correct. It's not a matter of whether it was good faith or bad faith. It's a matter of the fact that a Liz pendants was recorded, and the court recognizes as a reasonable inference that a party, that the purchasing party then doesn't have an opportunity to meet that deadline. It doesn't matter really if there's evidence at trial, that's the cause. Another point that's really
What's your best legal proposition for the fact that one can find something with in the absence of any evidence to support it?
because it is the absolute purpose of the Liz pendants to achieve that very goal.
Which goal? Can you be more
The
precise?
goal to interrupt the financing commitment and to stop the sale. And here's another important point too.
Before you leave that, just the record evidence of where you were in the process? I haven't read your record yet. So what is it going to show? I know there's a petition with 51 names on it, and I know they spoke to this financing, this group that helps people buy homes. Do we have more evidence of progress than that in this? I just haven't read the record yet. What is the record going to show us about what your clients actually did to get funding? and how far along they were?
They consulted with the nonprofit group that Mr. Danforth consults with, and through that group, and they hired an attorney through that group, and through that group, they applied for financing.
This whole issue of, I'm sorry.
I just have the last question on that. They applied for finance. Do we have a letter, something? I just want to, is there something concrete? Because you're a little loose on this.
I don't think there is, Your Honor. What we have is,
So I'm asking, don't intuit for me. What's in the record that demonstrates that there was a real financing application done here? Because
I think our best evidence is that ultimately they obtained the financing, but the timing of it, I don't think was really an issue.
in the record?
Yes.
I'm going to find that in the record.
Yeah. Here's the point I wanted to make.
Well, let me ask my question before you
Yes,
make
Your
the
Honor.
next point. As I look at the statute in 32 RC subsection 3 of the 90-day requirement, you're asking us to read into the statute a reasonable effort requirement, correct?
I believe that's correct to a point, Your Honor, but here's
It just says obtain financing, blah, 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 within 90 days. It doesn't say anything about use best efforts, excusable neglect,
that's right.
correct?
That's correct, Your Honor.
So what's the authority for us to read into that? Other than I guess the purpose of the statute, is that what you're telling me?
The purpose of the statute, which is to protect the residents and give them the right of first refusal and to make it easy. And second, the purpose of a lis pendens. But here's the point.
Well, I know the purpose of a lis pendens, and that's obvious, but have we ever read into these time commitments any type of excusable neglect?
No, Your Honor. And also, there have been a couple of cases addressing the right of first refusal, and also none have read into the statute that if you miss the closing deadline of the additional 90 days, that you also are then, your right of first refusal is extinguished, because as counsel pointed out, you can't close while the lis pendens
We haven't
is
got,
recorded.
you haven't gotten to that point because you didn't get the financing in time.
Well, that is true. We didn't get the financing within the first 90 days. But the point I've been trying to get at is this. To some extent, it's a moot point. We get the 90-day, if we get the 90 days, if we get the financing within the first 90 days in this case, we can't close. And the financing commitment is limited in time to just a few months. So it's really, to some extent, an empty exercise. The lawsuit is filed. We don't have our financing
So
commitment
you're saying
yet.
that the lis pendens is a poison pill, basically, that blows.
Yes, Your Honor. That's right. And that's what the appeals court found below. And we would ask the court to adopt that, because what is the point? Lawsuits filed before the 90 days run out. Lis pendens is recorded. Now we still have to go get the financing before the 90 days run out, even though we know and the lender knows that it's not going to, that there's no prospect of closing. So that just doesn't really make any sense. And I do think that it is a per se rule. The mortgage contingency is also sort of falls into this category. The statute has to be construed in a manner that reasonably achieves its goal. So strictly construed, we had a mortgage contingency. Was it substantially similar to the Crown purchase and sale agreement? And the answer is yes. It will eviscerate the meaning of the statute. It'll take away the right of first refusal if a mortgage contingency disqualifies the association's purchase and sale agreement.
Maybe not, but we can't really dispute that cash is materially better than a mortgage contingency. Okay, so if we begin there, and you can see that, at what point would a financing contingency become materially non-equivalent? Because there has to be some terminus to this, right? You've got a bona fide purchaser that's going to put $3 million cash, and you're cobbling together a simple majority of folks to say, hey, let's try to get contingency, let's try to get a mortgage. That's going to, all of these folks that come in, these atmospherics that come in to try to help these folks, seem to suggest that it's hard to do this. So at what point do we get to say, or do we find that mortgage contingency isn't materially equivalent?
Sure, and I think the statute addresses that in the following ways. Absent a lawsuit in a lis pendens, it anticipates that there's going to be a 90-day period to get financing. That's number one. And number two, and this is important, absent the lis pendens and absent a lawsuit, Section 32RC says that the deadlines can be changed upon agreement. We don't know if that.
See, that seems like a problem for you, because I was going to thank you for bringing that up. So you could have gone to the trust and obtained an agreement to waive the 90 days. Did you do that?
I don't think we did, because once the lawsuit was filed and the lis pendens was recorded, that ended the discussions between the parties on doing anything with this deal. And the owner took the position that it was just going to stay neutral and step back and not get involved. So that really wasn't an option.
Okay. Thank you.
Thank you. I see my time is up. Thank you.
Thank you, Chief Justice Budd. Good morning. May it please the court. Assistant Attorney General Michael Turi here on behalf of the Attorney General. Your Honors, I'd like to start in the same place that my fellow counsel did, which is the purpose of this statute. And I want to make a point that in the Attorney General's view, the purpose of Section 32R is actually uncommonly clear. It's to favor resident ownership of manufactured housing communities, and indeed to favor such ownership over third-party ownership. And we know,
Is it to favor ownership or to protect their right, to protect them from ending the mobile home community and leaving them homeless? I mean, aren't they neutral on who's operating one of these things? I mean, I know that if there's going to be a change of control, they get a right to intervene, but this is a little different than what the legislature's worried about.
so I actually don't necessarily think that's right, Justice Kafker. And the reason that I feel that way is because the legislature recognized, and we know this by the way it changed the statute by amending it in 1993, that anytime there is third-party, commercial private ownership of a manufactured housing community where people own their homes but don't have control of the land beneath them, there is an inherent risk that it will someday be discontinued. So what the legislature was concerned about was that inevitably at some point there is going to become a period where these parks could be discontinued, and that means that the affordable housing is permanently cut from the market. And in 1993, the legislature changed the statute to account for that, because originally in 1986, residents only had the right to go through what was back then a much more complicated process. They needed to incorporate, they needed to send a certified letter demonstrating that a residents association had the legal ability to negotiate on behalf of a majority of residents, only if there was going to be a discontinuance or a change in use. And then in 1993, when the legislature amended the statute and made it substantially more permissive, it broadened that out to any scenario where the park was being sold. So I think the purpose really is the same either way. It's meant to be protective and ensure that where residents want to exercise that democratic process, they have the ability to take control of the land.
But it's not an unlimited, I don't want to call it right, but it's not an unlimited statutory benefit to these resident groups, because the time limitations in the statute seem to me to indicate a legislative desire to protect the interests of the current landowner as well, right? So that they're not hung up indefinitely waiting to find out what's going to happen to the property, and perhaps even an ancillary benefit to the proposed third-party, let's say, investor group looking to purchase it. So it's not a unmixed legislative purpose, I think, here. Would you agree with that?
Yes, I agree, Justice Wallochian.
All right. So then I have a question for you about the deadline for obtaining financing.
Yes.
It sort of sounds to me as though, in the view of the Resident Association and the Attorney General, the filing of the lis pendens essentially acts as a tolling mechanism for the deadline in the statute for obtaining financing. And can you see that view of the argument that's being forwarded?
So, Your Honor, I appreciate that question because I do want to address the lease pendens. We did not address this in our brief. We kept it rather tightly focused on the two issues on which this court sought amicus participation, but the Attorney General views this as critically important to protecting the residents' interests. And our view is that a lease pendens categorically, as a matter of law, just interferes with the residents' rights under the statute. And the reason we know that is because this court, and I'll give you what I hope will be a helpful case site, Deborah Realty versus D. Chiara, that's 383 Mass 559. This court held that as a matter of law, lease pendens operates. The whole point of the instrument is to prevent financing and to make it difficult, if not impossible, for another party to get a mortgage on a property. That is the entire purpose of the instrument. And if this court concluded that, every time there's a lease pendens, residents have to start, calling financial institutions into evidence and, really get into questions about how much it delayed, whether it resulted in worse terms, it's obviously going to incentivize a third party. This will be the first thing they do. How difficult can we make it? How impossible can we make it for residents to go?
Sure. So do you have examples of a similar situation where we have then taken this external factor, in this case, the filing of a lis pendens and its legal implications, and used that to find, let's just say, an exception to statutory language which otherwise appears on its face to be mandatory? Do you have any cases where we've done that kind of statutory construction? We have language from the legislature saying imposing a mandatory 90 days, and yet we've said, oh, that can be, there's an exception to that because this other thing happens. So that's why I see it as sort of like treating the lis pendens as a tolling mechanism for the deadline imposed by the statute. And I'm wondering if we've done something like that in any other context.
So, Your Honor, I don't have a case off the top of my head. Our view, and first of all, as a practical matter, we didn't brief this question. We would be happy to submit a 16L letter if the court would find it helpful. But I do think where there's such an obvious, and again, not fact-specific, but as a matter of law, impairment of residents' rights, there has to be some kind of remedy that's appropriately tailored to the statute's purpose. And Justice Rubin talked about this a bit in his concurrence on the previous appeal. It may be simply appropriate that these lis pendens motions should not be allowed in manufactured housing cases where the right of first refusal is still live. It may be that they should be promptly dissolved. Or in this case, I think the appropriate remedy is exactly.
So I know that you're not really to speak on this issue, but it seems to me that that position, the one articulated by Judge Rubin, would be to the detriment of the rest of the world by precluding the notice of a lawsuit related to real estate. Why would that be reasonable?
Sure. So moving into the third point I was about to make there, it may be that the appropriate remedy is, in fact, to allow the motions, but to excuse the deadline to some extent as an appropriate way to protect the residents' rights while that instrument is still live.
Can you give me that site about the lis pendens that you gave us a little bit earlier? And what year was that?
Sure. That's a case called Deborah Realty versus D. Chiara, 383 Mass 559, an SJC case from 1981. It was deciding the constitutionality of the lis pendens statute, and it upheld it as constitutional to impose the instrument without a hearing for affected parties. But in doing so, this court extensively discussed just how burdensome a lis pendens can be. It effectively acts as an attachment.
The reason we gave you permission to speak was on the regulation. I'll give you 2 minutes to talk about that.
Yeah, thank you, Justice Gaziano.
And to tell us why just a signed document is sufficient in the AG's regs.
Sure, Your Honor. So I think it goes down to the definition of reasonable. And that's one point on which all of the parties agree, which is reasonable. And Crown acknowledges this in its principal brief on page, I think, 36. Reasonable in this context basically means plausible, right? It means possibly correct, conceivably true. It does not require absolute certainty. It doesn't require evidence to be perfect. the legislature could have required, under something more akin to a clear and convincing evidence standard, something like what it did in
They can
1986.
still challenge it, right? It's easy to get 51 people to write something down, particularly when they don't understand it. So I take it they can still dig into that, right?
So when you
You're
say
not
they-
saying that, one thing I just want to make sure, the AG is not saying that if they put a piece of paper that has 51 names on it, that's good enough? Is that maybe good enough, or is that definitely good enough? What are you saying?
So I think it depends. So in Crown's brief, they're primarily talking about judicial review, whereas we're talking about the operation of the statute, which is that the decision maker here, the reviewer, is going to be the community owner. And the question of whether it's good enough, I think we address in our brief. And the point here is really,
Well, I'm just trying to, we have to operate in the real world. I'm just trying to understand. We're holding up a sale based on a piece of paper. Again, I just want to make sure, what is the AG saying about, when you submit 51 names on a piece of paper, what is the AG saying the legal effect of that is?
so the AG is saying that under the regulation that's at issue here, 51 names out of, I assume, 100 people is going to be enough to meet that plausibility threshold. And in fact, may, under the circumstances, be strong evidence where the decision maker, in this case, is not a
It can
court.
be challenged or it can't be. When they challenge it, they have the right, are you suggesting they've satisfied that statutory requirement, or just that it's prima facie case of it? I'm just trying to understand what you're saying.
So in terms of they challenge, Justice Caffrey, do you mean like in a lawsuit?
Yeah.
I think a court has the ability to take into evidence and to consider the reasonability, or excuse me, the reasonableness of evidence that residents provided, just as the court did here, as we know it did on remand, because it did that analysis of the
Wait, so
signature.
your position is that 51% of the resident owners is enough to trigger the right of your first refusal once it's submitted to the owner, but then afterwards, the third party bona fide purchaser for value can then challenge whether they actually got to the 51% or not. And then that would, poof, the right of first refusal goes away.
So first of all, we don't take a position on the standing question, which I think is a threshold issue there. But, and we, just as an obvious point, we don't expect that those lawsuits would be filed unless there is in fact some evidence that the plaintiff could demonstrate that there were improprieties, with the petition. If the petition,
Or they just think people don't know what they're doing, meaning they don't understand they're signing that piece of paper, they're making a commitment to buy it's a big commitment.
This is a challenge there's a name that says Fred Flintstone on it. They can go to court and say there's no Fred Flintstone that lives here, right?
so I think, Your Honor, it wouldn't even get to that point because one of the key points we've made in our brief is that a community owner who's presented with a petition or a list of signatures has to determine under the plain language of the Attorney General's regulation whether it was in fact signed by such persons. If there are
Right,
obvious
but I think
indicia
that
of fraud.
the next question is, can that 51% be challenged by somebody who says, hey, Fred Flintstone is not really a resident?
Assuming without taking a position on the question of whether the challenging party, a would-be putative purchaser has standing, I think the answer has to be that is an option that could be available to them.
I'm sorry?
That the answer would be yes.
Yes, okay.
And would that also extend to withdrawals?
In terms of the withdrawn signatures?
Yeah.
So our position on the withdrawn signatures is that the judge appropriately refused to discount them for the reasons that I think the court articulated in the discussion, earlier this hour, which is that the statute places, pretty clearly articulated timelines on how this is supposed to work. Residents present reasonable evidence, a substantially equivalent PNS, and then it triggers the next step in the process. The PNS gets executed. And so to require residents to go back and the owner to start considering, like a moving target and the goalposts keep moving is going to be really burdensome, not just on the residents' rights, but on the owner, who's never going to know when this is going to stop. And I just don't think that's what the legislature intended here.